this morning on the Ag Issues program. Pleasure, as always, to bring back to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program this morning. Roger, good morning. How are you?
Hey, good morning, Greg. Just doing fine. Apparently, I was in one of those scattered areas of rainfall this morning. It started raining about 5 o'clock and ended about 20 minutes ago.
Another shower, and I think that's going to be the theme of today as well. And let's get to it. We, or as you have deemed, continue to see major problems with the donation of permanent conservation easements. And specifically, there is a case you want to talk about. That's and my apologies if I pronounce this incorrect, the Oconee Landing case, which you deemed as, to say the least, an absolute mess right now.
Yeah, Greg, this is, and I think you pronounced it right. I don't know. I think that's how it is pronounced. This is out of Georgia. And I would say since the beginning of the year, there's been at least a dozen of these cases decided by the tax court or other federal courts across the country. IRS is all over this. So if you get into donating a permanent conservation easement on your farmland, you can expect the IRS to audit that one and examine it very closely. This one, fascinating set of facts, because what's involved, let me just back up, and for people that aren't familiar with this, what the concept involves is placing a conservation easement on your property and donating that to a qualified charity, such as a land trust. And we have, for example, the Kansas Land Trust in the state of Kansas. There are numerous types of qualified land trusts all over the country. And they have to meet certain requirements to be able to accept that land. And the benefit of doing this for a farmer or rancher is that if you are a qualified farmer or rancher and the donated property is used in ag or livestock production, then your deduction can be up to 100% of your contribution base. There are limitations for people that aren't qualified farmers and ranchers, but if you are, and you meet that definition, then your deduction is 100% of the value of that donated easement, 100% of your contribution base. And so valuation is the actual key to this. There are a whole bunch of technical requirements, but how you value the property is very important. And that's what IRS looks very, very closely at, in addition to all the other technical rules. And basically, the way you come up with the value of the donated easement is you take the value of your land before you donate the easement, and then the value of your land after the easement is donated. And the difference is the value of your tax deduction. Of course, you have to hire appraisers to do this, and they have to be qualified appraisers. You can't just do this yourself. So this is big-time stuff, and usually what we're looking at are donations that are in the millions of dollars. You've got to really put the effort in on this and spend a lot of money on preparation fees to get this done correctly. But the deduction can be huge. What happened in this case, Greg, was that you had the chair of the Georgia real estate section of the Bar Association and the head of the Georgia Society of CPAs that got themselves together and they said, well, we got this property down here. It's adjacent to a very prominent golf course, and we've got a large tract here. And we think to attract investors, we can jack up the value of the property, and we're going to set up a prearranged deal with appraisers and say, we want you to come in and value this at $60,000 per acre. That will attract investors, and then we're going to claim that the easement is worth $60,000 per acre. Well, long story short, one, you can't predetermine what your value of the easement's going to be, so you can't set this up like this and tell your appraisers where you want them to come in at. And then you can't claim, as the court said, the easement is not worth more than the underlying property itself. So the whole thing was phony. There was a criminal aspect, the criminal side of this. That case was last year, and these people got in some big-time trouble for doing this. But this just points out, and while there can be benefits to this, it's just that the IRS has looked so hard at this. This is one area where they examine the returns very, very closely. So for those listening that are considering doing this, I know there are donated conservation easements on land in the Flint Hills. It's a big concept, particularly out in Colorado and in the Mountain West. But you've got to be very, very careful, because this is one thing that the IRS has its eye trained on for sure.
Because you could easily, or I'm assuming you could easily fall into that trap saying, hey, let's do this on this, not realizing what the IRS could do at the end with very, very much auditing those types of transactions.
Yeah, and because of the dollar values involved in these, Greg, it's worth it to the IRS to spend time examining these. The anticipated deduction in this case was $20.67 million, and the court whacked that down to $5 million. And, of course, tacked on penalties, both a 20% and a 40% penalty for understatement and associated fraud. So you really have to know what you're doing. You have to hire professionals that are competent to help you with this. Your CPA, your lawyers, the drafting of the deed. The deed has to be, that donates the easement itself has to be drafted very specifically. And so this is very technical stuff. Again, it can be a very useful concept. And we've had these in Kansas, in Kansas, and particularly in some areas of the Flint Hills. But just be very, very careful when you get into this. That's the message that I want to get across.
Another topic of discussion that you had on the docket today concerns the IRS, but their changes on their position on gift tax treatment of IDGT tax reimbursement clauses. IDGT is Intentionally Defective Grantor Trust.
Yeah, we call it an IDGT, and that's a tool that's used by some larger estates in estate planning to keep assets out of the grantor's estate at death, while at the same time the grantor is still responsible for paying income tax on the trust's earnings. And you might say, well, why would I want to do that? Why would I want to transfer my property away from me but still pay any income tax on the income generated by that property that I just transferred away from me? Well, the idea is that we do this from a transition planning standpoint. If we're transferring a business, we're transferring assets to the next generation, maybe family assets, maybe a farm. An IDGT is an estate planning tool that can accomplish that goal. And I can keep that further appreciation in land value, for example, out of my estate. And if Congress does nothing, which they tend to be pretty good at doing, the federal estate tax exemption will collapse down to about half of where it will be in 2025. It'll be about half of that in 2026. So we're going to have more people and more farms and ranches that are potentially subject to federal estate tax. Well, this is a tool that can keep that enhanced value of your estate out of your estate. And if you've got enough income, you can pay the tax. If you've got enough cash flow, you can pay the income tax on that appreciation, so your heirs don't have to pay that, and that property in the trust continues to grow even faster because the tax burden is not on that property. Well, I mentioned if you have the cash flow to pay the tax. If you don't, it's been possible in the past to give an independent trustee of that trust discretion to distribute funds from the trust back to you as the grantor to make those tax payments. And the IRS has said in the past, well, that won't trigger any gift tax or income tax consequences. But now they've changed their position on that, and they say that a reimbursement clause like that in an IDGT does trigger gift tax when the trustee distributes trust funds to the grantor to pay the tax. So we're going to have to think through the lawyer community that drafts these things. We're going to have to think through how we can deal with that. I think, and even though IRS didn't address the issue in this most recent chief counsel advice, I think it would seem that if state law allows the trustee to reimburse the grantor, as long as the trust doesn't prohibit reimbursement, no gift tax should be triggered. But we're going to have to think that one through a little bit more.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us on the program this morning. Roger, a couple of Supreme Court cases that were 9-0 unanimous decision for landowners. There were wins for landowners on the topic of Fifth Amendment takings claims.
Yeah, and the fact that they both were 9-0 in favor of the landowner tells me that the government is out of control in these cases. Very rarely do we see the U.S. Supreme Court issue 9-0 opinions, and even rarer are they 9-0 on issues such as environmental law or WOTUS, for example, or property rights. But we saw it 9-0 last year on one aspect of the WOTUS opinion, the Sackett opinion that came down May 25 last year, involving the definition of what a wetland is. They were all in agreement that the government and the Biden administration was wrong with respect to the definition on that. That was amazing. Now they weren't unanimous on how we determine what a WOTUS is, but they were unanimous that the government was wrong in that case. So that was incredible. They were all together on that one. And here we have two more involving takings. The first one you and I have talked about before. And this was this farmer down in South Texas whose farm, his ranch got flooded as a result of road improvements done by the state of Texas, which basically turned his farm and his ranch into a retention pond. And he sued for a taking. The state said, well, you can't sue us because only a government entity can sue us. There's no statute. Congress has never allowed people to sue the state. And they kicked it into federal court. It got removed to federal court, and he lost in federal court on the same issue. And basically, the issue was that the Fifth Amendment is not, as it said, self-executing. There's nothing that says what you do if your land's been taken, even though the Fifth Amendment says the government is to pay you what's called just compensation. That's your remedy. It seems like the remedy is built right into the language of the Fifth Amendment itself. Well, it gets to the U.S. Supreme Court, and while they didn't directly answer the self-executing question, they did kick it back to the federal court in Texas to say that, well, the state law down in Texas has a remedy here, and it's an inverse condemnation action, so you need to retool your complaint, and they're going to be allowed to do that. They're going to get their day in court down there, and that was 9-0. The other one was a landowner, I shouldn't say a landowner, a property owner out in California who had a lot, and this is in an area between Sacramento, California, and Lake Tahoe. So if you've driven that route, it's a really beautiful drive to go about 2 hours between those two locations. So he's in between that area there, and he's got a lot. He wants to put up a prefab house, an 1,800 square foot house on that lot, and the county said, well, you got to pay us $24,000 as a traffic mitigation impact fee. And so he paid the fee, but he sued for a taking. And based on prior cases back in the 80s and early 90s, the court said 9-0, yeah, county, you've got to show that your burden here is closely related to the benefits that you're going to receive. So the burden on the landowner has to be closely related to the benefits that the county in this instance would receive. And they said, obviously, it was not. So they struck down that traffic impact mitigation fee. And that's something that we have to watch state and local governments do. They like to do those types of things, and sometimes they can get out of line. And this one's way out of line.
You had mentioned the Sackett case concerning WOTUS, and you've got a couple of examples of that the WOTUS issue is not going away, but you talked about the federal government being out of control. And in this case, sounds like with these two cases, the federal government's not abiding by last year's Sackett opinion.
No, they're not at all, Greg. And this is unfortunate. One involves an Iowa farmer down on the Missouri border in Decatur County. I would say if people are familiar with, you drive up Highway 30 or Interstate 35 out of Kansas City, go up to Des Moines, you just cross into the state line and off to the east just a little bit. That's where this farm is at. He's just over the line into Iowa. But this is where this is at. And the government is not paying attention to the test in Sackett where they said in order for a tract to be a WOTUS, subject to the discharge permit requirements of the Clean Water Act, you have to have a continuous surface water flow from a relatively permanent standing or flowing body of water that is connected to a WOTUS. Well, this guy's about 100 miles from a WOTUS, and he's got basically a dry ditch that sometimes will hold water for a while when you get a heavy rain. And they're claiming that he needs an expensive permit and is subject to the Clean Water Act process to build a pond. He wants to build a fish pond on his farm. The other one is in North Carolina, and this fellow bought 1,700 acres to prepare it for a logging business, and he was issued a cease and desist order back in 2018, being accused of filling a WOTUS. He deeded some ground back to the government as a permanent conservation easement to separate, as we talked about earlier, to separate the alleged wetland from a tributary to a WOTUS. And the government, once they got that, said, well, that's not enough. And so they kept prosecuting him. Forest roads are exempt from Clean Water Act regulation anyway. And that's a problem here. And the other situation here is that the government's theory is based on a position that the Supreme Court rejected in the Sackett case last year. So, no, they're not paying attention to the Sackett opinion.
All right. And Roger, if people want to learn more or want to get updates on these cases as well, they obviously can go to your blog to be able to do that.
Yeah, I've written about all of these in the past, Greg, and I'm going to update it again because we could have a major monumental shift in tax policy that will affect farmers and ranchers here, depending on what the U.S. Supreme Court says in another case, and that's also something that you can find on my blog. That's known as the Moore decision. And then we've also got a decision the Supreme Court will decide based on buy-sell agreements, and that's big, too. But those can be found on my blog. You can find that at the homepage of washburnlaw.edu/WALTR. I also share those with Ag Manager over at K-State.
All right, sounds good. Roger, as always, appreciate it. Know you're busy, but thanks for taking the time to join us once again.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he has been our guest on the Ag Issues program right here on 580 WIBW.